Order. This is meeting number 13 of the Standing Committee on Access to Information, Privacy and Ethics. It is being televised as requested, and the order of the day pursuant to Standing Order 1083H6, study on allegations of interference in access to information requests. We have two panels of witnesses this morning. First, our first witness is Mr. Sebastian Togneri, former Parliamentary Affairs Director, Department of Public Works and Government Services, and he is accompanied by his lawyer, Mr. Jean-François Lecoeur. And we've discussed earlier, Mr. Lecoeur is here to be able to advise his client, but he may not address the committee. Welcome, gentlemen. Before commencing, I want to confirm to the committee that I have a written opinion from the law clerk that I referred to, and I'd like to read from it. Simply put, no proceeding elsewhere prevents anyone, a member, a minister, or a private citizen from appearing before a parliamentary committee. Whether the sub judice rule should apply depends on the circumstances and the nature of other proceedings and on the willingness of the committee or committee members to apply the rule. Arguably, the sub judice rule applies only to matters before the courts. This matter is not before the courts, and I would not believe that sub judice will be an issue, so we are free to proceed. I also, colleagues, this morning had a conversation with the Information Commissioner, who had indicated to Mr. Togneri, and we had received correspondence from his counsel concern about appearing here. She has indicated to me that she's not aware of any questions at this time that should not be asked, or that she would have some concern about.
Point of order, Mr. Chair.
Just a moment.
No, I do have a point of order.
Just a moment. I will get to it.
No, but point of order does interrupt your.
No. I will deal with it when I finish what I'm doing right now. Okay. That the she understands fully and appreciates and agrees with the position advised, the opinion advised to us by the law clerk, and she would be prepared to appear before the committee should the committee wish so to discuss this matter any further. Given that, I think that committee members are also aware that there is another proceeding going on, and we don't want to frustrate it, but it's very clear that the committee's priorities and its ability to do the job cannot and should not be interrupted by any other proceedings. Now, Mr. Poliev, on a point of order.
You indicate that the Ethics Commissioner, sorry, the Information Commissioner had communicated to you that no questions asked by this committee would cause any problems with her investigation. Can you table the letter in which she communicated that to you?
That was a conversation this morning. She phoned me.
So you have no written.
I will get her to put it in writing.
So we have your interpretation of that conversation?
You have what I was told this morning, just about an hour ago, by the Information Commissioner. And
you have no documentation to carry that forward to us?
It was a telephone conversation from her at her request.
So do you have any documentation at all? You don't. I do, and it's from the Information Commissioner, the Assistant Information Commissioner, Andrea Neal, who has a confidentiality order pursuant to Sections 34, 35, 36, and 64 of the Access to Information Act, in which she writes that Mr. Togneri shall not disclose any of the questions asked, answers given, and exhibits used during his examination under oath before the Council of the Information Commissioner on March 23, 2010, in any manner to anyone until the Information Commissioner's investigation is complete, except to his counsel, Mr. Jean-François Lecoeur. So this is an order from the Information Commissioner, and you have now put this particular witness in a position where you are demanding of him something that he has been ordered not to provide. You make a claim that you have had a conversation with the Information Commissioner's office. You have no documentation to support your interpretation of that conversation. We, on the other hand, do have documentation straight from that office, which I'm prepared to table.
All right, thank you. No, I appreciate that. Mr. Polyev and colleagues, we received this communication, a copy of it from Mr. Lecoeur, which was raised at our last meeting. I undertook to get an opinion from the law clerk. I gave a verbal, but I have it in writing now. And the law clerk has clearly stated that notwithstanding the Information Commissioner's Office communication, that the committee's rights to hear a witness cannot be overridden by any other proceeding. And I, this morning, when the Ethics Commissioner she called yesterday and asked to speak with me at actually 9 o'clock this morning. There were two matters. The first is not relevant to this committee, but she did want to offer with regard to the matter that you have just raised, that she confirmed to me verbally that there was no concern from the Information Commissioner's Office with regard to Mr. Tonieri's appearance before this committee today. So, having said that, I appreciate the information, but we are going to proceed with this witness now.
Point of order, Mr. Chair. Point of order.
Point of order, Mr. Polyev, please.
You're asking the witness to just take your word for it when he has a written document from the office in question.
Okay. Order.
Instructing him to the contrary.
Mr. Polyev, sorry.
And
Mr. Polyev,
it is
please.
not your role to impose rules and interpretation information.
Mr. Polyev, order. I've already ruled that the opinion from the law clerk with regard to the authority of this committee to proceed supersedes the other order. It does, in my opinion, and that's my ruling, and we are going to proceed now with Mr. Tonieri. Right now, Mr. Tonieri, you told me you had...
Order, Mr. Chair.
Point of order, Mr. Bazan.
Okay, just since we are going to proceed with the questioning of the or hearing from the witness, I just want to draw to your attention the Rules of Government Committees, Chapter 20, page 1068. Particular attention is paid to the questioning of public servants, and as we know, Mr. Tonieri is a public servant with the Department of Public Works and Government Services. The obligation of the witness to answer all questions put by the committee must be balanced against the role that public servants play in providing confidential advice to their ministers. The role of the public servant has traditionally been viewed in relation to the implementation and administration of government policy rather than the determination of what that policy should be. Consequently, public servants have been excused from commenting on policy decisions made by government. In addition, committees ordinarily accept the reasons that a public servant gives for decline to answer a specific question or series of questions which involve the giving of legal opinion, which may be perceived as a conflict with the witness's responsibilities to the minister, which are outside of their own area of responsibility or which might affect business transactions. Carrying on 1069, witnesses appearing before committees enjoy the same freedom of speech and protection.
Can you slow down for the translation?
Okay, witnesses appearing before committee enjoy the same freedom of speech and protection from arrest and molestation as do members of Parliament. At the committee's discretion, witnesses may be allowed to testify in camera, dealing with confidential matters of state or sensitive commercial or personal information. Under special circumstances, witnesses have been permitted to appear anonymously or under a pseudonym. So I would suggest that since we are dealing with sensitive information here involving an investigation by the Information Commissioner, and based upon the practices of the House, and that we are directed by O'Brien, Bosk, and by the standing orders, that we should take into consideration that if we're going to hear information that Mr. Tonieri is going to present today, and he has been advised, as Mr. Polyev has already said, by the Assistant Information Commissioner, that this should be done in camera.
Today is the Easter motion, which says that the committee's study regarding allegations of systemic political interference by ministers' offices to block, delay, or obstruct the release of information to the public regarding the operations of the government departments, and that the committee call witnesses, one of which is Mr. Tonieri. It is my ruling, Mr. Bezan, that this is not a matter of sensitive, secretive information. This is, in fact, a study of a committee seeking to get the facts as to what the operations are as it relates to the matter of access to information requests. This is not a specific allegation against anyone. It is simply a study of this committee. Accordingly, I will rule that we are going to proceed with the witness. And Mr. Tonieri, I would just indicate to you that refusal to answer a question is not an option. However, should you believe that there is substantive reasons why you cannot, I would request that you would give that reason to the chair, and I'll make a ruling. Okay? Let's proceed. Thank you. Is it necessary? All right.
I do
Mr. Easter, on a point of order, are you saying?
Point of order that the witness be sworn.
Okay. Seeing other. Okay, would you please swear in the witness? Yes. Excuse me.
I, Sébastien Tonieri, do solemnly, sincerely, and truthfully affirm and declare the taking of any oath is according to my religious belief unlawful, and I do also solemnly, sincerely, and truly affirm and declare that the evidence I shall give on this examination shall be the truth, the whole truth, and nothing but the truth.
All right. Mr. Tonieri, please proceed with your opening statement. Thank you.
Mr. Chair, thank you for allowing me to make these opening remarks. First, allow me to state my complete respect for Parliament and its committees. Prior to joining a minister's office, I was the lobby assistant and worked closely with all parties with respect to the running of the House of Commons. In that role, I learned a lot about parliamentary procedure and developed a deep appreciation for this institution and those who serve it. I fully respect the powers of the committees to examine all matters that fall under their mandate and the motions they adopt to study those matters. If you allow me, I will take a moment to expose the chronology of the events that led me to appear before you today. La commissaire à l'information, qui est une...
The Information Commissioner, who is an officer of Parliament, is conducting an investigation into a complaint under the Access to Information Act against the person responsible at Public Works Government Services Canada. Because of that investigation, I testified on March 23, 2010 at the office of the Information Commissioner. During that testimony, I received the following order of confidentiality under sections 34, 35, 36, and 64 of the Access to Information Act. In a complaint under the Access to Information Act against the person responsible at Public Works and Government Services Canada, and in business concerning access to information with regard to that complaint conducted in secret and ex parte in the absence of the person responsible at the department in question, the Attorney General of Canada, and the complainant pursuant to the Act, pursuant to sections 34, 35, 36, and 64 of the Access to Information Act. And the powers of the Superior Court, the Assistant Commissioner has ordered the following. I, Sébastien Tonieri, will not communicate either the questions that were asked or the answers given or the documents used during the testimony by the counsel representing the Access to Information Office on March 23, 2010, in any way to anyone until the investigation of the Commissioner has been completed except to her counsel, Mr. Jean-François Lacour, signed by Andrea Neal, Assistant Information Commissioner. With your permission, Mr. Chair, I would like to table this document.
A week after I received the order from the Information Commissioner that I just read and tabled, your committee, the Standing Committee on Access to Information, Privacy and Ethics, adopted the following motion: that the committee conduct a study regarding allegations of systemic political interference by ministers' offices to block, delay, or obstruct the release of information to the public regarding the operations of government departments, and that the committee call before it, I include all the names, including myself, Sebastian Tangeri, former Director of Parliamentary Affairs, Public Works Canada. Now, when I received this motion asking me to appear before you, I asked myself the following question: does this committee's motion go against the order I received from the Information Commissioner, who herself is an officer of Parliament? If so, should I decline the request to appear? I have to admit that I didn't intuitively have an answer to this question, not being a lawyer myself. Because of my respect for this institution, I decided to agree to this request. That's why on Friday, April 9th, I sent an email to the clerk of this committee agreeing to come before you on April the 15th. I have to admit to you that immediately after having agreed to your request, I started having doubts. I wonder if I had acted appropriately in accepting the request. While I was reflecting on this, the clerk answered my email and indicated that the committee couldn't hear me on April 15th and suggested another date in May. Before accepting this new date, I decided to consult my lawyer, who reviewed the order from the Information Commissioner and your motion requesting that I appear. He advised me that I should decline your request as it goes against an order from an officer of Parliament conducting an investigation. A letter to that effect from my lawyer was sent to the clerk of this committee on Wednesday of last week, April 28th. Last Tuesday, May 4th, I received a summons signed by you, Mr. Chair, indicating that I was required to appear here today. The summons indicated, and I quote, "Failure to appear may lead to proceedings against you for contempt of Parliament." Permettez-moi de relire ce paragraphe.
Allow me to reread that paragraph from your order in French. The failure to appear could lead to procedures of contempt of Parliament.
Mr. Chair, I agreed to come before you today. That being said, you and this committee must understand that I am bound by the order from the Information Commissioner that I tabled and read today. I apologize in advance to this committee if I am forced to refer to that order instead of answering in detail the questions that this committee will pose to me today. La commissaire à l'information.
Information Commissioner of Canada was very clear when she wrote that I could not discuss about anything concerning the investigation, and I quote, "in any which way to whomever until the investigation of the Commissioner has been completed."
Information Commissioner clearly instructed me to not disclose anything regarding the investigation in, and I quote, "any manner to anyone until the Information Commissioner's investigation is complete." Voilà, Monsieur le Président.
You have it, Mr. Chair.
Thank you, Mr. Tanieri. And as I had indicated to the committee at the last meeting and again today, the opinion of the Law Clerk of Parliament, which incidentally mirrors the decision of the Speaker of the House with regard to the Afghan detainee documents, reaffirms the full authority of Parliament to call for persons, papers, or records, and that authority of Parliament and of the House of Commons has been delegated to all standing committees, including this one. So we have this full authority That is the opinion of the clerk, and as I had indicated to the committee, I have spoken directly to the Information Commissioner, and your words about not about any matter on anything, that is not exactly what it says here. It says with regard to the questions or answers that you gave. We don't know what those questions or answers are. What we do know is that that proceeding will take months, maybe years, before it's finished, and it would be unreasonable to deal with that. So I've made a ruling on that, and I thank you for your input, but we're going to proceed, and as I indicated, I encourage you to answer the questions. So Mr. Easter, please, 7 minutes.
Thank you, Mr. Chair.
Mr. Chair, point of order. And
Just a minute, Mr. Easter.
Okay.
Mr. Bazan, I've made a ruling very clearly, and I've repeated it 3 times. So I'm trying to, I don't want to anticipate what you're going to go after.
Exactly.
But if you want to discuss that any further, your recourse is not, again, to make the same argument. You must challenge the ruling of the chair, and that's the way.
This is a separate point of order, Mr. Chair.
All right. I just wanted to make that clear.
And Mr. Chair, I'll just draw your attention to Chapter 3 of O'Brien Bosk, as it applies to my rights and privileges as a member of Parliament, that the chair of committee does not have a power to censor disorder. Page 150. I'll let Mr. Easter reference it. So you don't have the power to censor disorder. You do have to manage it, and I appreciate that. As a chair of the committee, I understand that. But you have to allow all the members here a right to debate points of order, and you can organize that the way you see fit. But you can't just go out and start censoring people from speaking, because that then is impugning our ability to have our freedom of speech. That is a right that we have here as members of Parliament.
Just a moment, Mr. Bazam. With due respect, all I did was to remind you that I had made a decision on certain questions and that I would not entertain further discussion, and that your option would be to challenge the chair's ruling. You then advised me that you have a different point of order, and I recognized it. I don't think the censorship allegation is appropriate, and I would ask you to withdraw it.
I do withdraw.
Thank you. Carry on. You have a point of order?
Yes,
please.
and I'm just trying to reference it here now. But the concern that I have is that you're talking about the law clerk's letter, and I agree that as committees and as members we have the power to investigate things that are substantive that we feel that's important as standing committees. But as standing committees, we're still governed by the House. We are we decided that we are masters of our own domain under procedure, but essentially we are created by the House, and we are responsible to the House, and we need to make sure that we respect the rulings from the House. And so we want to make sure that when we are questioning a witness, that we are making sure that the rights that they're granted under O'Brien Bosk, and as I stated earlier, 1068, that as public servants, he doesn't have to answer all questions put to him, especially if it affects the study and the inquiry that's being conducted by the Information Commissioner. So I would just ask that you consider that, and as questions are being asked, that you call those what are admissible and what's not admissible. I'm just asking you to use your...
Mr. Easter, please.
Point of order before I get to my question, Mr. Chair. I do have a question because it seems to me, Mr. Chair, that what we're seeing here is
Mr. Easter, in fairness, Mr. Bazan, although he indicated it was a different point of order, it wasn't. It was continued debate on the prior discussion, so it was not a point of order, and we're going to move on with your
No, Mr. Chair,
okay,
the member...
that's fine. We can
no,
move
there
on
was
to
no
questions.
point of order.
So I'll just make
there
my
was no
point in my
order.
introduction to my question,
Okay.
Mr. Chair.
Please.
Because it seems to me what we're seeing from the Parliamentary Secretary to the Prime Minister and from Mr. Bazin is that we're really seeing collusion and coaching from the government to a witness that's before this committee that we're trying to find out information on relative to the Access to Information Act. That concerns me greatly, because we seem to be seeing more and more of deny, delay, and cover-up from the government, and the performance of government members in this committee just can't lead me to any other conclusion. But to my question, welcome, Mr. Tugneri. It is kind of too bad that we had to basically present an order to bring you here, but in any event, thank you for coming. I want to background the issue where this issue really to a certain extent started, and just so that we all know what we're talking about. In a CP story by Dean Beebe, February 7th, I quote, it said, a federal cabinet minister's aide killed the release of a sensitive report requested under Freedom of Information in a case eerily similar to a notorious incident in the sponsorship scandal. A bureaucrat had to make a mad dash to the department's mailroom last July to retrieve the report at the last minute under orders from a senior aide to then Public Works Minister Christine Paradis. The order was issued by Sebastian Tugneri, Paradis' Parliamentary Affairs Director, in a terse email after he had been told the file was already on its way to the Canadian press, which had requested it. Quote, well, release it, Tugneri said in a July 27th email to a senior official in the department's Access to Information section. That's basically the background to why we're here, in part why we're here today. So my question to you is, are you aware that your interference in the ATI, Access to Information process, is an offence under the Access to Information Act?
Mr. Chair, thank you for the question. I refer you to the order from the Information Commissioner that I tabled today, which says that Mr. Sebastian Tugneri shall not disclose the questions
Order.
asked.
Mr. Tugneri, you've indicated that you would invoke the opinion of your lawyer and et cetera, and I'll take that just on you do not want to answer with regard to that position. What I would say to you is that in my view, the question asked to you has nothing to do with secrets or confidential information. This is a question to you personally, and I'm going to instruct you to answer the question.
Point of order, Mr. Chair.
Point of order, Mr.
Yes, the question is indeed out of order. In fact, it is.
Order.
I'm trying to help you bring order.
Mr. Poilievre, please. Mr. Easter has a line of questions. He has the full latitude to pursue whatever he wants, but he's asked a very direct and clear question. To challenge whether a member's question is in order is simply not a point of order. It's up to the chair to determine, and I indicated to Mr. Tugneri that I believe that it's a straight question. It has not anything to do with private, secret, or confidential information. It is asking for his knowledge of the Access to Information Act, which is related to the work that he does. So I don't want to waste any more time of this committee's
Sorry,
meeting.
Mr. Chair, that was not my point.
Well, there was no point of order. There was a debate. So I have to move on back to Mr. Easter, please.
You responded to my point before hearing it.
No. If we're going to have points, your challenge, your point of order was that his question is
The chair has a lot of powers, none of them telepathic. You don't know what my point is, therefore you cannot respond to it.
I'm going to Mr. Easter, okay? Carry on, Mr. Easter.
Point of order, Mr. Chair. Point of order, Mr. Chair.
All right. What I'd like to do, I've been patient, but what I'd like to do at this point is I would like to ask members who wish to raise points of order, which is their right, first of all, to state clearly the basis for the point, rather than have a bit of a story leading up to it. I want to know the basis for the point of order. Could be something like relevance, could be repetition, could be not related to the matter before this committee, okay, stuff like that, but very specific. Okay? So, Mr. Bazan, what is the nature of your point of order before you start debating it?
So my point of order is Standing Order 117, very specific to committee. The chair of a standing special or legislative committee shall maintain order in the committee, deciding all questions of order subject to an appeal of the committee. But disorder in a committee can only be censored by the House on receiving a report thereof. And I referred to your powers as chair, procedural responsibilities, page 1030 of O'Brien-Bosk, chapter 20. Says that they ensure that any rules established by the committee, including those of apportioning of speaking time, are respected. They are responsible for maintaining order and decorum in committee proceedings, referring to your work, and ruling on any procedural matters that arise subject to an appeal of the committee. So, furthermore, the chair does. But anyway, what I'm getting at, is, Mr. Chair, is that you have to recognize points of order, and that if any member is raising a point of order based upon any of the questioning here, you have to hear those points of order as outlined in Standing Order 117. And if you feel that things are getting out of control, Mr. Chair, then you can report this back to the House if the committee agrees to it. So anyway, I just wanted to raise that with you.
Thank you. Mr. Tanieri, please answer the question.
In response to the question, I'm not here to give opinions, legal opinions. I'm not a lawyer, and I am unable to give that kind of legal opinion.
Okay. My recollection is, what the question was, were you or are you aware of these sections of the Act? No. Okay, we're going. If I may, if I'm mistaken,
you are.
Mr. Easter is the questioner, and I'll ask him to pose pose the question again.
Yes, Mr. Chair. Just a point. First, before I get to, I hope all the government's points of order on delaying here is not coming out of my time, because
no, carry on, but it's going now.
Okay, that sounds good. The question specifically was, Mr. Chair, are you aware that your interference in the ETHI process is an offence under the Access to Information Act? That was it specifically.
And my answer is I'm not here to give legal opinions. I'm not a lawyer.
It's not, with all due respect, Mr. Tognery, it isn't a legal opinion. It is whether you were aware whether there was interference. But set that aside, then, if you're not willing to answer that question. In terms of that interference, was Minister Paradis or anyone at the PMO or PCO aware that you were instructing the bureaucrats to on-release a report, the report, that already was on its way to the media?
Mr. Chair, I again refer to the order from the Information Commissioner I tabled today.
I would submit to you, Mr. Chair, that question has nothing to do with the order of the. This is a direct question to you, whether your minister or anyone at PMO or PCO was aware that you were instructing the bureaucrats to on-release a report that they were prepared to release. That was the question. It's got nothing to do with the order of the Access to Information Commissioner or your letter, or the letter that your lawyer sent us.
Mr.
Point
Chair,
of order, Mr. Chair.
Stop the clock, please. Point of order, Mr. Polyev.
Yes, we are in the process of conducting.
Please state the
figure
actual
20.5, page 1064, chapter 20.
That doesn't tell me anything. Give me the nature of the point of order before you start giving.
Well, I'm going to cite right out of the book.
Give me the title of it.
Usual order of business for committee study learning to a substantive report. Decisions to study. We have here in this figure a list of steps that are involved in carrying out a study of the kind that in which we are now engaged. And what I've learned by looking at this figure is that the way in which you are carrying out this meeting is in violation of that order of business. The steps are as follows. A decision to conduct a study is made. Drafting of work plan, schedule, and a witness list is established. Briefings to committee members are provided. Hearings of witnesses and gathering of advice and opinions is produced. Proceedings relating to the draft report, which will come later. Review and revision and adoption of the draft report, presentation of the report to the House of Commons, and finally, the government response if the standing or special committee has requested one. Now, the most important step of all in this is the second last one, which is the presentation of the report to the Parliament. And that is because this committee is an arm of the House of Commons, and it works for the House of Commons. The House of Commons has established an information commissioner through legislation, through statute, through law. That information commissioner has issued an order. That order has been provided to the witness in writing. To counter that, you have produced a rough regurgitation of a conversation that you claim to have had this morning at 9 a.m. And you have not produced any documentation to support either the existence of that conversation or its contents. Right now, you are in the process of demanding that the witness violate an order provided to him by an officer that is created through statute of the House of Commons, and if that House is supreme, then so too are its laws. And we, as a committee, cannot instruct the violation of those laws. So, I would ask that in the interests of the rule of law, you advise members to cease all questions that would violate a written order from an officer of Parliament whose powers are laid out in statute adopted not only by the House but by Parliament itself. That is my point.
Thank you. No. I'm just going to rule on this.
Mr. Chair?
The Chair is going to rule on this now. Mr. Polyev has indicated under O'Brien Bosk, specifically with regard to the matter of usual order of business for committee study leading to a substantive report, and specifically talk to the step of presentation of a report to the House, which we haven't done yet, and hopefully if we keep going like this, I don't think it ever will happen. But what I object to, Mr. Polyev, what I object to is to use that point of order, which is obviously not applicable at this time, to go back and to challenge the Chair's ruling on the ability of this committee to deal with this witness. I could also indicate to you that the committee approved the motion and the witnesses and the summons that I issued to bring Mr. Tonieri here, notwithstanding that we had the letter from his lawyer and a copy of the ruling from the Information Commissioner's office. I have made that rule, I've made that decision that we are proceeding because we have the right and the authority and the duty to discharge these responsibilities that the committee has adopted and is proceeding with and in the middle of. Mr. Tonieri is one of the last witnesses. So, I don't want to hear any more argument about whether or not this committee has the right to do what it's doing. The committee approved it. The Chair is following the instructions of the committee and call the witnesses. I issue the summons with the authority of and the approval of the committee. The witness is here, and I would suggest to the witness as well that to invoke the letter from the Information Commission is no longer a valid reason because the opinion of the law clerk of the House of Commons is that our work supersedes the investigation and the matters before the Information Commission. That is the opinion from the clerk. That is the opinion and the decision that I have taken. And I am going to go back to questions now from Mr. Easter. He has still a couple of minutes left. And I encourage you, sir, not to invoke the Information Commissioner's Office matter. That has been superseded. We are proceeding under the authority of the Parliament of Canada. And the members have the right and the delegated authority to do this. And I'm going to ask first of all, I'm going to ask all honourable members not to go back over that other ground, to repeat this thing. The decision's been taken. The chair has affirmed more than once today that the opinion of the law clerk and my decision stand. And if the committee members believe that the chair is in error in that decision, your option is not to raise a second point of order on the same matter. It would be to challenge the decision of the chair. So, if everybody understands clearly, I'm going to go back to Mr. Easter. Mr. Easter, you still have a couple of minutes.
Thank you.
And I would suggest to all members that we get to questions rather than speeches. Okay?
Because of the deliberate attempt by government members to prevent us from really getting to information here, Mr. Chair, I'll review the first two questions. Mr. Tugneri, you refused to answer whether or not you were aware that you interfered in the ETHI process. You refused to answer whether or not you were, whether Minister Parity or anyone at the PMO or PCO were aware that you were instructing the bureaucrats to unleash the report. My third question, I would hope you don't refuse this because I think you're very close. In fact, I would suggest that you may be in contempt of this committee on refusing to answer these questions based on the ruling of the chair. But in terms of interfering in the ETHI process, were you acting on instructions from anyone else when you intervened? From anyone else?
Mr. Chair, thank you for the question. Again, I'm put in a very difficult position. I have a confidentiality order pursuant to sections 34, 35, 36, and 64 of the Access to Information Act that states that I am not to give any answers nor repeat the questions during my examination under oath before the Council to the Information Commissioner.
I've heard. Again, I'm going to suggest to you that if you're going to want to invoke that, I've made a decision on that already. But if you don't need to read it back to us or the other details. If you just indicate that, because I'm just going to take note of the questions that you have refused to answer. But I want to proceed, and I'm going to go now to Madam Freeman for her 7 minutes, please. Point of order, Mr. Bazin.
Thank you, Mr. Chair. Just wanted to, because we have a witness that definitely has some difficulty answering the questions, that committee has, as described in Chapter 20, 1068 of O'Brien Bosk, that the actions of a witness who refuses to answer questions may be reported to the House. So we always have the power to do that, and I think it wouldn't be a bad thing to do, to report it back. And I just wanted to also reference page 994, which committees are bound by the orders of reference or instructions and may not undertake studies or present recommendations to the House that exceeds the limits established by the House, which you're suggesting that we have, the law clerk is suggesting we have more powers than the House, which I think we need to have that clarified, since the House has a public office holder being the ethics or the information commissioner, who is definitely reports to the House and the Speaker, and so we need to keep that in mind. And also, I just want to keep in mind too that for Mr. Terneri's sake, that the idea that committees are masters of their proceedings or masters of their procedures, as quoted on 1047 of O'Brien Bosk, is frequently invoked in committee debates or the House. The concept refers to the Freedoms Committee normally have to organize their work as they see fit, an option they have of defining on their own certain rules of procedure that facilitate the proceedings. Continuing on to 1048. These freedoms are not, however, total or absolute. First, it is useful to bear in mind that committees are creatures of the House.
Order, please. You've already done this once and gone through it.
Not this part, sir.
This, when you say that we have somehow taken the decision that is contrary to the rights of this committee, that, sir, is totally incorrect. We've got the opinion. We've made a decision on that, sir.
Back to my original point.
And this has nothing to do. Yes, your point was that we could report it to the House if we have a problem.
Yeah, and I want to go back to that.
And, sir, the committee, not the chair, will decide if we do that when we finish our meeting with this witness. Okay? We're going to deal with that at the end of the questioning of this, because we need to know what questions are asked and which questions have been answered or refused to be answered. And we don't know. We can't anticipate those questions, but I've noted that the witness has not yet responded to any questions.
I'm just suggesting, in this report,
sir,
in the report, Chair,
which we will talk about when we finish.
There's conflicting legal advice coming from the law clerk and coming from the information commissioner.
Sir, I hear you, and I understand, and we will, if the committee so decides, make a report to the House on this matter. But we're not going to do that now. We'll do it when we're completed with the witnesses. Okay? Thank you. Madam Freeman, I'm sorry, but we're going to carry on with this witness until we have the full normal time, that the 2 rounds, okay? We'll have to reschedule. So, Madam Freeman, please.
There are currently allegations of systematic political interference from ministers' offices with regard to retaining information and the publication of information. My question to Mr. Togneri, the first question is, are there processes or directives to manage access to information requests within the Minister's Office at Public Works, where you worked at?
For the question. First of all, I want to say that I'm not refusing to answer any questions. I was asked a legal opinion, and I said that I'm not a lawyer, and therefore I have no opinion on legal matters. I was also asked
Je m'excuse, Monsieur le Président.
Mr. Chair, my question was very clear.
Okay, your time is wet. We'll get back to it. Mr. Tanieri, I would appreciate it if you wouldn't go back to some other questioner's questions and try to explain what you said or didn't say. We have a transcript. Madam Freeman has asked you a question. Madam, would you please repeat the question for the witness, and I'm going to ask the witness to please respond to your question.
Mr. Chair, I might ask my question in a different manner, but I do hope that won't infringe on my time. If I have to re-ask the question, you will restart the clock, please. Thank you, Mr. Chair. So, my question was, once again, are there allegations of systemic political interference within Minister's Office to prevent the publication of information? Are you aware, or did you receive directives to manage access to information requests? Thank you, Mr. Chair, for the question. I would like to ask for some clarification. Are you asking whether there were directives from the department? From whom? My question is exactly that. Is there a process? Are there directives in place to manage access to information requests? By whom? By the Department of Public Works? Well, currently, but you are here because you interfered in the publication of a report. You blocked access to that report, and I'm wondering who gave you those directives. Was it your minister? I received no directive from anyone. So what you're saying under oath today is that you acted by yourself and in contravention of the Act and what the minister could expect from you.
Is that correct?
Monsieur le Président,
Mr. Chair, I submit that I never said that I contravened the Act, and I think that the question jumped to conclusions. That's my response. The Act states that no one can block or access to a document or prevent its publication. The fact of having prevented publication, as you did, contravenes Section 67(1) of the Access to Information Act. And there are criminal consequences to such acts. Did you or did you not block access to that information? And did you receive directives to do so? Or did you do so on your own and contravene the Act directly, and therefore you were responsible for those actions? Or did you receive directives? And what I want to know is whether you received directives or whether there's a process in place which you are subjected to, or did you act on your own? That's my question. Well, I believe I've already responded to the question with regard to the directives. There were no directives which were given to me. As for the other question, once again, I think that you're jumping to conclusions. I never admitted that I contravened the Act. Very well. I'll have another question for you then. Did you receive or were you aware that access to information requests were made to the Minister's office? Did you receive yourself access to information requests in which you were involved? Were access to information requests submitted to the Minister's office? Thank you for the question. If I understand correctly, do we see access to information files? Yes. We see those files. So you see access to information request files which are submitted to the minister. They're submitted for information. And do you see them regularly? Do you see such files regularly? I'll rephrase the question. Are all requests forwarded, or is this only on occasion? During what period are you talking about? I'm only asking you whether you are aware of that during your time at the department. At that time, yes, I received a number of access to information files. What was the nature of those files? Were the files that you received with regard to the identity of requesters, or the scope of those requests?
Point of order, Mr. Polyev.
My point
Please
of order
state the specific.
deals with relevance, and I refer you to page 32, chapter 1, under Parliamentary Institutions. Title: Responsible Government and Ministerial Responsibility. Responsible government has long been considered an essential element of the government based on the Westminster model. Despite its acceptance as being a cornerstone of the Canadian system of government, there are different meanings attached to the term responsible government. In a general sense, responsible government means that a government must be responsive to its citizens, that it must operate responsibly, that it is be well organized in developing and implementing policy, and that its ministers must be accountable or responsible to Parliament, whereas the first two meanings may be regarded as the ends of responsible government. The latter meaning, the accountability of ministers, may be regarded as the device for achieving it. Now, the reason that this relates directly to the relevance of the questioning is that for the questioning to be relevant, it has to be posed to the relevant authority. And the relevant authority in this case is a minister of the Crown. We have in this country something called ministerial responsibility. We didn't invent it. It was handed to us from the birthplace of the parliamentary system. It goes back hundreds of years. Neither you nor this committee nor anyone else can rewrite that history. As such, it is appropriate that ministers respond on behalf of their departments and on behalf of their ministries. That is why we had the Honourable Diane Finley appear before us in her capacity as the Minister of Human Resources just last meeting. She fielded questions about the subject of costs for an advertising campaign and was held accountable for exceeding the standards of transparency that exist for advertising. And today we have questions about the conduct of a given ministry, but we do not have a minister here to answer those questions. Instead, we have here before us someone who has been instructed by the Information Commissioner that he cannot comment. So, in the interest of respecting ministerial responsibility and its description on page 32 under Parliamentary Institutions, I would ask that the committee allow the minister to be responsible for the conduct of the department and the ministry, and to operate on that guiding principle here. That's my point.
That's your point. Okay, I just wanted to see how long you were going to go. So, respectfully, colleagues, this is not helpful to the committee to raise points of order on one matter and to go back to arguing the initial decision of the chair that the Information Commissioner's communication does not supersede the authority and the work of this committee as approved by this committee. The calling of this witness was made by the committee decision. The argument that somehow a minister must respond on behalf of their staff, Mr. Polyev, I submit to you that, as you know, ministers cannot be called before committees, ordered to come before committees. And in fact, we have just recently, Minister Raitt and Minister Parody have refused to go to the Standing Committee on Government Operations. Ministers cannot respond if they refuse to appear. Now, the committee did not ask for the minister, and if the member would like to guarantee that the relevant minister will appear before this committee to answer these questions, that would be very helpful, and I hope that the member will make that inquiry. Having said that,
you've posed a question to me, Chair.
Just a moment. No, that's a rhetorical question because I know what the answer is. Mr. Polyev, the other point that you raised was that this idea that this witness cannot answer questions because it's the ministerial responsibility. Well, with regard to Madam Finley, Minister Finley, we have called a witness, Mr. Ryan Sparrow. She is aware of that. Her chief of staff was aware of that. We've had some conversations, and Mr. Sparrow has agreed to appear before this committee on the 13th of May of his own volition without me having to issue a summons. He's coming voluntarily to answer questions, and therefore his decision, with the full knowledge of the minister, would tend to refute the argument that you've made. So I'm going to rule against your point of order, and I am going to have to move now to Mr. Sixay for his 7 minutes. Madam, your 7 minutes was up. Thank you.
Mr. Tonieri, I wanted to ask if you had been officially delegated authority by Minister Parody to have any role with the Access to Information Act or the Access to Information procedure.
Mr. Chair, thank you for the question. No.
So there was no ETHI delegation order from Minister Parody that officially named you?
Thank you for the question. The answer is no.
Mr. Tonieri, were you unofficially delegated any authority by the minister to have a role with access to information in his office?
Could you, Mr. Chair, could you be more precise?
Informally, without, in the absence of a specific delegation order, did he ask you at any time to assume responsibility for that in his office?
If I understand you correctly, I would have been responsible for reviewing access to information files. Yes, I guess would be the answer.
Okay.
There was no written or delegated authority per se, but informally, yes, I would.
Can you help me understand what Minister Parody meant when he said publicly that you specifically, and I quote, won't be in charge of access to information files anymore? Can you tell me what the minister meant by you being in charge of access to information files?
I would suggest that you should maybe ask the minister that question. I can't answer for Minister Parody.
Did you have a sense in the minister's office that you were the person in charge in terms of political staff of access to information?
The answer to that, Mr. Chair, would be yes, I looked after them.
Did you have a written job description, Mr. Tonieri, with regard to your role as Director of Public Affairs in the minister's office?
I actually don't recall. I started in July 2008, and I believe I signed. I signed a job offer, and I can't remember if that job offer had the specific details, but I don't think so.
So you're not aware of any specific requirements that were made of you in writing around the Access to Information Act?
No.
Okay. Did you receive any training with regard to your role with regard to the Access to Information Act or with regard to the Access to Information Act itself?
Yes, we all, when we all started at Public Works, we all got briefings on access to information. Yes.
And as part of those briefings, was Section 67(1) of the Access to Information Act, was that part of the training that you received with regard to the Act?
I'm sorry, could you
was any
remind
reference
me
to Section 67(1) with regard to political interference and the penalties and the seriousness with which the Act takes that? Was that part of your training?
Can you just hold for a moment, please? I would request to see the documents so that I can review it and so that I can answer more properly.
I could read you the whole section of 67(1). I'm sure you're aware of it now, however, but you don't recall ever being that being part of the discussion when you were being trained with regard to the Access to Information Act.
I don't recall, but
okay.
If it's an important part of the Act, then I imagine it was. Yeah.
Okay. Mr. Tonier, did you participate in meetings with PMO issues management staff as part of your work before Minister Paradis?
Yes, I did.
And was the Access to Information Act a subject of discussion at those meetings?
I don't recall. No.
You never recall that being on the agenda of those meetings or coming up in the course of those meetings?
I recall that we should be vigilant and watch, do our job and review the access to information requests.
So when you say vigilant, do you mean vigilant in the sense of ensuring that information was released appropriately, or do you mean vigilant in terms of protecting your minister or the reputation of the government or protecting the government from the release of sensitive or embarrassing information?
No, vigilant in the sense that we know something, if an access to information requests, we know it's going to be released, that we are well prepared to answer any questions either in the House or through the media.
So in terms of preparing the minister for the release of that information in that sense?
Yes.
Did you feel pressure from the PMO or the Privy Council office to head off the release of sensitive or explosive information?
No.
Did you feel pressure from the PMO or your minister to take a hard line on releasing information?
No.
Did you ever get yelled at by officials of the PMO because information was released from your minister's office that they felt was sensitive or embarrassing?
No.
Did you experience other political staff being dressed down, criticized, or ridiculed because information was released from the office of the minister that they worked for?
No.
When your minister's office was notified that information was about to be released as part of an access to information request, were you the person who would have received that notification in terms of political staff?
If you mean, did I'm sorry, can you be more precise?
Well, if the department, the ETHI officials were recommending release of information, were you the person on the minister's political staff who would have received that notice of the impending release of that information?
Yes.
And what process did you engage at that point when you received that notice?
We would have how it would usually work was that we would have, and again, this is all, again, I'm put in this difficult position because I'm not supposed to talk about this, but
well, I'm not asking you to reveal the questions that were put to you by the Information Commissioner's office, Mr. Tonieri. I'm asking my own question, and I'm not asking you to release anything about the investigation that's underway there. I'm asking you a question: what your role was when you received that notification that information was about to be released. What did you do at that point?
Under my delegated, under the delegated authority, I just reviewed the information and made sure that our communications was prepared for any answers or any questions that might be put to my minister.
But you told me earlier that you didn't have delegated authority, Mr. Tonieri.
That's why I said that I didn't have delegated authority, so I would receive the information, the access to information request, and I would ensure that any policy advisor or communications person be prepared with lines.
Now, did you vet the information or seek changes to its content?
Mr. Sixay, I apologize. I have to be fair to all members.
Thank you, Chair.
We'll get second round. Mr. Poilievre, please. 7 minutes.
Thank you very much, Mr. Chair, and I'd like to thank the witness for appearing. And I know that you've been put in a very difficult position because you have an officer of Parliament who's created by statute, by law of the House, by law passed by the House and Senate, telling you not to speak about matters related to this investigation. Then you have that order in writing, and then you have a chairman of a committee telling you that he's had a conversation with that same commissioner saying the exact opposite. And it must be difficult for you to know what you're being asked to do, and when an arm of Parliament is telling you not to speak about the matter, and then a chair of a parliamentary committee is telling you that you must speak to the same matter. And it must further complicate the fact that the whole matter must be further complicated by the fact that this chairman has not provided any written confirmation of the conversation he claims to have had this morning with the Information Commissioner. So I'll pose my questions in recognition of the fact that the chairman's conduct has put you in some state of
point of order. If Mr. Poilievre had a problem with the chair, they could have challenged the chair. Okay. They didn't challenge the chair, and all Mr. Parliamentary Secretary to the Prime Minister is doing, all he's trying to do is cover for the government by attacking the chair. It's unacceptable at this committee.
That's okay.
Point of order,
How far will the government go to subvert Parliament? How far will it go?
Order. From time to time, members don't like what others are saying during their questions. But members have rights to ask their questions and make their statements and use their time as they wish. I know I get a little concerned when people start to characterize what I said or what I've done or what I haven't done. I'm not sure. I can defend myself, though, because we have a remedy to this, and I will propose it to the committee at the end of the meeting. But having said that, I did stop the clock. That's not a point of order. I understand your frustration, Mr. Easter, but we've got to respect the member's rights to use his time in a manner which he feels is fit. That's his right. So I have just a little over a minute and a half used up, so you have still 5.5 minutes, sir. Please proceed.
Thank you, Mr. Chair. And I have a great deal of sympathy for what you're confronted with. And I have to say that this chair in particular has, in prior meetings, she, in my view, in my judgment, done quite a good job of carrying out the business of this committee. And I don't know what's happened today, but it isn't consistent with his track record, unfortunately. So my first question to you is as follows. You have served the Canadian people in your role as a political staff member of the political staff personnel. Do you consider it to be a privilege to serve in that capacity, to serve your fellow Canadians in that role?
Mr. Chair, thank you for the question, and it's a great privilege to work as a political staffer in this government. Absolutely.
Right. And how long have you had political positions around Parliament Hill?
Thank you for the question. Other than my stint as a parliamentary guide in 1999 and in 2001, I've been on the Hill since November 2004.
How many people would you have guided through Parliament's halls during that time as a guide?
Probably tens of thousands.
Tens of thousands. And during that time, you would have elevated the importance of Parliament in their eyes.
Absolutely. I have a great respect for this institution, and I was always interested by the political process, and felt privileged to share that with visitors. Usually it's their first and only time to come here, and I loved to educate them on that process.
On the importance of Parliament, the importance of ministerial responsibility, which is one of the principles of Parliament itself.
Absolutely, of responsible government and ministerial responsibility, absolutely.
Right. And, you know, in all the splendor of the halls of this place, you get the sense that the thing that holds it all together is the fact that ministers, in their role, defend the actions of the executive branch of government. And while they can't be expected to have perfection for amongst all of their employees, both ministerial and bureaucratic, that they answer for their departments and their ministries.
That's my understanding of this, yes.
Right.
Absolutely.
Good. Well, given that tradition that in which you were prepared for your role now, that tradition of telling thousands of Canadians about Parliament, it is clear that you have a background in this parliamentary tradition and that you have shown respect for Parliament. And I want to close by pointing out that members across the way asked some extremely inappropriate questions, particularly the member for Malpeque, when he presumed an outcome to the Information Commissioner's investigation. He said that there was a breach or an infraction of the law. In fact, that no such breach or infraction has been found by the Information Commissioner. Is that correct?
That is correct. She has not reported back on my testimony, and I imagine the testimony of others.
And that's probably one of the reasons why she provided you with this order, because I don't think that she needs her investigation interfered with by politicians, whether they be the chair of a parliamentary committee or a member of the opposition caucus.
Mr. Chair, thank you for the question. And again, that's precisely why I refused to come in the first place, or in the second place, I should say. And of course, my respect for Parliament and this process, when I was summoned, I was not going to put myself in a position to not show up and then be in contempt. So that's why I'm here today, answering your questions.
And I want you to know that you have, I think you have demonstrated your willingness to cooperate with this committee. You've answered questions where you have been permitted to answer them. And I would encourage you to continue with your long track record of service to the Canadian people.
Wow. Thank you.
Super. Thank you kindly. We'll move on. This is round two. Madam Foote, 5 minutes, please.
Thank you, Mr. Chair. And thank you, Mr. Togneri, for appearing before us this morning. Canadians, including the media, have the right to access to information that the government has, and certainly under the Access to Information Act. I'm sure you would agree with that.
Yes, thank you for the question. Absolutely.
Are you aware that interference in the ETHI process is an offense under the Access to Information Act?
Yes, absolutely.
Would you consider then your actions when there was a bureaucratic response prepared and sent to the mailroom, and then you instructing a bureaucrat to, as you said in your email of July 27th to a senior official in the department's Access to Information section, well, on release it, would you consider that to be interference?
Thank you for the question. I don't think je me suis pas ingéré dans le processus.
I didn't interfere in the process, and the Office of the Commissioner is conducting an investigation as we speak. And if there was something bad done, well, there's an investigation underway.
Memos that were sent out by the Prime Minister's office through Mr. Durno with respect to interfering in the process in terms of access to information.
Thank you for the question. Which memos specifically?
Well, actually, there were several sent out, and all of them pointed to reminding political staff of their responsibilities with respect to access to the Information Act, and that they were not to be involved in that particular access to information or interfere with it in any way.
Yes, I am. I am aware of those memos.
And at this point, then, you don't think that any of your actions did anything that was contrary to what Mr. Durno had indicated to political staff that they were supposed to do or not do?
I'm sorry, could you be more precise in the instructions?
Well, what
given?
Mr. Durno's memos here, in fact, staff members should also be aware that subsection 67(1) of the Access to Information Act makes it an offense to obstruct the right of access. No person shall, with intent to deny a right of access under this Act, and he lists, destroy, mutilate, or alter a record, falsify a record or make a false record, conceal a record, direct, propose, counsel, or cause any person in any manner to do anything mentioned in any of paragraphs A to C. It says, while most political staff members are familiar with the law and their responsibilities, it is useful to refresh their knowledge and awareness. And I want to go back to the request that you asked to have on released. And in looking at the A, B, C, D, destroy, mutilate, or alter a record, clearly when that information was ultimately released, what had been prepared by the bureaucrats, I think, was something in the order of 132 pages, and what finally went out were 30 pages, I think is what it was. So I guess I'm just asking, would you not consider that to be altering a record?
Monsieur le Président,
Mr. Chair, the question is asking me to interpret the Act. That isn't my role. That is to interpret legislation. As I indicated,
I did not have delegated authority, and therefore any decisions of how a document is released was never mine.
So you had no part to play in making sure or ensuring that the document, the 136-page document that you asked to have on released, ultimately ended up to be just 30 pages.
Thank you for the question. I have no role to play in that.
So the only part you played, or the part you played, was to on-release the document. And whose direction did you do that?
There were no directions from anybody. I did send in a hurry a stupid email, as I would put it, and I refer you again to the fact that there was no delegated authority, and it was a mistake on my part, and that's all I have to say.
Was it a mistake on your part as well to say, what's the point of asking
Madam
for my
Clerk,
opinion if you're just going to release it?
I apologize, Madam Clerk.
I'm sorry, thank you.
I'd indicated the time was elapsed. If I may, before I go to Madam Block, we also have witnesses today from the Department of Human Resources and Skill Development, as listed on our thing. It would appear, since this meeting has to end at 1 o'clock, that we will not be able to hear those witnesses. You're excused, and we will communicate with you about reappearing. Given the break week that involved, my estimate would be that a week from today, we may be able to accommodate you for the last hour. Okay. Thank you. Madam Block, please.
Thank you very much, Mr. Chair, and thank you, Mr. Tonieri, for being here today. I recognize, as my colleague has, that having you come has put you in a difficult situation in terms of the directive from the Interim Information Commissioner and what we have heard from our chair today. We have been having this ongoing study on access to information, and there have been communications and letters, open letters, that have talked about the ability for an information commissioner to release information in terms of any kind of investigation that is going on. And we know full well, when we look at the information, the Access to Information Act and the Lobbying Act, that those things cannot be released until an investigation is completed. And so I recognize that there is an investigation going on, and we know this because the acting information commissioner has announced that is happening. I can't. Today we learned that the member for Mississauga South had a private telephone conversation with the commissioner in the midst of an ongoing investigation about that investigation, And I'm assuming that when he came forward to the committee today and said that she had assured him that no questions that we might ask today would hinder her ability to conduct her investigation unimpeded. I guess I can't imagine what questions he might have known any of us would ask, to have sort of vetted those through the Information Commissioner to ensure that they would not be problematic either for you or for her. And so I just think it was highly improper to have a private conversation and then not provide us with any information to indicate that she had in fact given our chair that information. No member has the right to interfere in an ongoing investigation, and that's been made very clear in other matters, and no member should engage in a private conversation with the Commissioner in the midst of an ongoing investigation about that investigation. There were no witnesses, and we don't know what attempt was made to not influence the investigation, and we don't know whether pressure was brought to bear. And the Liberals appear to have a hard time recognizing this. The Commissioner is responsible to Parliament collectively. She does not work for any individual member, and no individual member should try to give her direction. I guess I do have a question for you, just in regards to perhaps your understanding of the work that you do. And I just want to ask this one question. Do you believe it is important to be open and transparent in the work that you do?
Thank you for the question, Mr. Chair. I believe it's absolutely important to be open and transparent with the work that I do. And again, I have ultimate respect for the process and the committee here, and that's why I'm here. Again, I was put in a difficult position, and what has happened here is that I've broken my confidentiality order to be here today, and not to be here, but with how I've testified, and I hope the Information Commissioner's investigation will not have been hindered too much by what's gone on here today, and that's about all I'd like to say about that.
Thank you very much.
Madam Freeman is going to be after that, and then we have Mr. Sixay.
Bonjour, Monsieur Tonieri.
Good afternoon, Mr. Togneri. Thank you for appearing. When the media asked Mr. Paradis, he said he wasn't aware. Can you confirm that to us? Thank you for the question. What exactly are you talking about? I'm talking about the facts that are alleged. When the media asked the minister, Minister Paradis said he wasn't aware of the situation. First of all, thank you for the question, but you would have to ask the minister himself. No, I'm asking you whether do you confirm that the minister was not aware of the situation? He said that you did not sensitize him to what was going on. Can you confirm that? I did not inform him of, if you're speaking about the ATIP request, no. Have you already read the Access to Information Act? I've had training sessions when I began, but to read it from beginning to end, no. You spoke earlier under the about the delegated authority, and then you came back saying that you had no delegated authority. Who had that delegated authority then? Well, the delegated authority rested with the officials, the access to information officials. Do you have a name to give us? No. Who is paying for your counsel? Yourself or your employer?
Read the summons that brought me here today. Take notice that you are hereby summoned and required to appear in Ottawa and give evidence before the Standing Committee, Access to Information, Privacy and Ethics of the House of Commons of Canada on matters relating to its study of allegations of interference and access to information requests on Thursday, May 6th. Star Block. I don't think these matters are related to the study of allegations of interference and access to information.
Was with regard to who is paying your fees, the fees of the lawyer. It may be relevant. Maybe the member could elaborate on the relevance of the question. I think that's what the witness is suggesting, that he's not sure that it's relevant.
In fact, I was asking the question because you thought it would be appropriate to come accompanied with a counsel. And you are calling on his services, I think, in the midst of the questions we're asking you. And so that's the relevance of my question.
Merci pour la question.
Thank you for the question. I don't believe that your question has any relevance with the reasons.
The pertinence of this question.
Don't debate it. No, this. Let me just
point of order.
Just a moment. Order, please. Just a moment, please. Order. I want to remind all honourable members that to say the words "point of order" is not a proxy for "I want to speak." There must be a specific point of order, and if it persists to be an abuse of the opportunity, the chair has a responsibility to keep order of the committee and may in fact not recognize a member who has been persistent in abusing that opportunity. Mr. Workington, you asked for a point of order. Please, specifically, what is the character of the point of order before you start arguing or describing it?
Yeah, exactly, Mr. Chair. What I was actually going to ask you specifically, Mr. Chair, is if you could rule as to if this was relevant to the study by which we've been called. So I specifically was curious about that. And was wondering
Mr. Workington, we've dealt with this a little earlier. That members have an opportunity to have their time to make questions of the witness. They're having the conversation, and the witness has responded, and it's up to them. But it's not up to us to decide what a member can raise at this meeting and in the questions. It may have relevance. We don't know. It's up to the questioner to establish that or refute the claim. So it's not a point of order. What you've really done is you've decided to jump in on the conversation. Okay? So let the member use their time contiguously. We don't need to have any further delays because I do want to get through the rest of, and one of your members is going to lose his time to ask questions if we keep on this. So I want to move back to Madame Tilak to complete. She has 2 minutes left.
OK. Écoutez, aujourd'hui.
Well, I think we're being very clear. In order to respond to our questions, you're accompanied by your counsel to give you advice. When you say it's not relevant, you said at the outset that you would consult your lawyer. And I see that my question is quite relevant. We want to know whether Canadian taxpayers are paying for your counsel's fees, or whether the government is paying, or whoever. My question is very clear. Today, who is paying for Mr. Lecour's fees to give you advice in responding to our questions here in committee?
Point of order, Mr. Poilievre.
The member may or may not want to answer that question, but I want to point out that the witness may or may not want to answer that question, but I would point out that the member is asking him to divulge a solicitor-client privilege before this committee.
That is not a point of order. It's a matter of debate. I'm going to go back to Madame Tilak. I think Madame Tilak has indicated clearly what the question is and the reason why she asked the question. And the witness is the one, Mr. Poilievre, and to all honourable members, if a question is posed to a witness and they believe that there is valid reason that they cannot answer that or should not answer it, it is the responsibility and the right of the witness to do that, not committee members to represent the witness. Please remember that. Mr. Tonieri, you responded. Again, please respond again in the fashion that you feel is appropriate to the member's question. Start the clock again, please.
Les communications avec mon avocat.
Communications with my counsel are protected by solicitor-client privilege, and that's what I have to say. I don't think that the question is pertinent to the reasons why I was summoned here.
Please.
Je vais continuer.
Madam Freeman.
Pour compléter,
To follow up, I think that if it is as an individual and your relationship between yourself, I'm a lawyer myself, so if the solicitor-client relationship is invoked, that's because Mr. Lecour is there as a personal lawyer paid by yourself. But if Mr. Lecour is there and paid by the government to represent the government, you are no longer have to raise the solicitor-client privilege. Is the government paying to protect your interests, or are you paying to protect yourself?
And we're going to go on to Mr. Rickford after your answer.
Merci pour la question.
Thank you for the question. That has nothing to do with the issue being studied by this committee. And if you want to hold a committee meeting to discuss lawyers' fees, you can do so.
Thank you. Thank you, Mr. Chair, and thank you to the witnesses and counsel for this part of my time, or the sidebar chatter? Okay, thank you. Thank you, Mr. Chair, and thank you to the witnesses and your legal counsel for coming today. I have some questions for you, Mr. Tonieri, but I do have a bit of a preamble that I hope will not be interfered with. This is a key theme that's occurred today, and I'm a little bit disappointed, if I can speak frankly, because I had a thoughtful conversation with the chair yesterday, and since we're introducing conversations, it seems relevant to say that I took away a great appreciation for some of the finer points of participating in committee with him, only to come today and find out with some great disappointment that we seem to be in the business of trampling on more than a century of parliamentary custom, and in fact law as custom is related. We've seen an introduction of a conflict of laws, and it was brought in a rather curious way with a telephone call. We don't know whether the chair requested this conversation, whether the commissioner requested it, and we don't know whether the commissioner was aware that this conversation may in fact pose serious substantive concerns, at least from the perspective of myself. And I put it out there that I am a lawyer and have thought through all different kinds of scenarios with respect to this fact pattern, and whether the commissioner's response to an order by her office would seriously compromise that document and your ability to give thoughtful and effective testimony today to guide this committee in its work. I'm confused because I thought that the chair was in a position to provide guidance in a non-partisan kind of way, and my own observation saw an enthusiastic sort of partisanship that I think has really put this investigation of the office of this particular commissioner in serious jeopardy. That said, I have no doubt that you have found yourself in a situation today that indeed you may feel very uncomfortable having given any testimony that has to do with an ongoing investigation. Simple yes or no, do you feel that way?
Thank you for the question. Yes, absolutely.
It's unfortunate. So what I'm hearing you say then in that answer is that you indeed think it's inappropriate to have appeared at this committee when you're in fact relevant information is involved in an investigation. Is that true?
Thank you for the question. Yes, indeed that is true. On March 23rd, 2010, I testified under oath at the offices of the Information Commissioner, and I was given a confidentiality order, and I've had to break it here.
Similarly unfortunate. So I might respectfully submit then that we have gone down an improper road, and we may be looking at certainly a substantive cause, if you will, for interference in that investigation, and I'd like to put that on the record. But I want to focus in my last... am I running out of time? Is that what you're...
You have 30 seconds, sir.
30 seconds. Okay, well, I have some simple questions then. I want to just review this again. Do you believe that it is important to be open and transparent in the work that you do?
Yes, absolutely.
And have you, at all times, to the best of your ability, acted in an open and transparent way?
Yes, absolutely.
Thank you. I have no further questions.
Mr. Sixay, please, and I do need the last 2 minutes to instruct the committee on what happens next, so I'll have to cut you off, but I will make it up at an appropriate time.
Thank you, Chair. Mr. Tonieri, I just wanted to come back to a question that was recently asked of you. Can you tell us who had the delegated authority in Minister Parady's office for ETHI requests?
No one has delegated authority.
So there was no one in Minister Parady's office who had delegated authority in the department to deal with access to information requests? And you don't know the name of any person who had official delegated authority under the Access to Information Act?
You're asking who in the department? I don't know.
So even though you were the person that the minister had put in charge of access to information requests on his political staff, you have no idea who the people in the department were who had delegated authority to deal with access to information in the minister's office?
I don't know. I don't know if it's one person or more than one person. I don't know who has delegated authority.
Okay. I appreciate your answer, and I'm troubled by your answer, but I appreciate it. Mr. Tonieri, when you received notification of an access to information request that the release was pending or impending, did you often negotiate back with officials in the department about what would be released or when it would be released? Did you undertake those kinds of consultations and negotiations?
Once again, I'm not sure I really understand your question, but I'll try to answer it. I have no delegated authority to make any of those kind of decisions as to. So no, I don't have negotiating powers or.
Okay,
or so no.
Thank you. Colleagues, there is another committee meeting that I must attend on behalf of the Liaison Committee to approve travel budgets for committees, and I must be there. There's important votes. So we have to terminate this meeting shortly. I want to indicate, first of all, I'm sorry that the members thought to make some assumptions about what happened this morning with the Information Commissioner, but I think the members may want to rethink their logic when they understand that it was the Information Commissioner that called me. Okay. No, she called yesterday to ask to speak with me at 9 o'clock this morning. I was in my office at 9 o'clock this morning. The Information Commissioner called, and I took her call. That's how it happened.
Did you ask
so
her for written confirmation?
We will deal with this later. Now, under Mr. Tonieri, this Information Commissioner's or the Assistant Commissioner's statement to you with regard has put you in a situation where you have not answered a number of questions, or some questions you have only partially answered. As a consequence, I think it's only fair to clear this up. I will be undertaking to get in writing from the Information Commissioner a clear assessment and statement of the obligations that you have under that communication that you had have received, and to provide it and to be circulated in both official languages to the committee before the next meeting, because, sir, the summons indicates that you will remain in attendance until discharged, and I think under the circumstances, sir, it would be inappropriate for me to discharge you from appearing before the committee, and accordingly, I'm indicating to you that this summons remains in force, and I expect you to be here Tuesday, May the 11th, 11 a.m. in this room, unless otherwise advised of those details. Do you understand that order, sir?
I heard you. I understand.
Thank you.
We're adjourned.